I'd like to welcome everyone to meeting number 6 of the Interim Judiciary. Chairman Westerfield had to step out for about 10 minutes, so I will be taking over for that short period of time, and I would ask the clerk to please call the roll.
Senator Berg, Senator Carroll,
Here.
Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder, President Stivers, Senator Turner,
Here.
Senator West,
Here.
Senator Wheeler,
Here.
Representative Banta,
Here.
Representative Blanton, Representative Bratcher, Representative Cantrell, Representative Decker,
Present.
Representative Elliott, Representative Fisher, Representative Flannery,
Here.
Representative Heverin, Representative Kulkarni, Representative Lewis, Representative Maddox, Representative McCoy,
Here.
Representative Minter, Representative Mosier, Representative Nemus, Representative Petrie,
Here.
Representative Scott, Representative Stevenson, Co-Chair Westerfield, Co-Chair Massey.
Okay, you have the minutes from the October 20th, 22 meeting. Have a motion, have a second.
Second.
Have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Minutes are approved. We're going to jump right into the agenda. It is not a lengthy agenda, but an agenda that I anticipate will generate a lot of discussion. So I would ask that Senator Ralph Alvarado please come to the table. This is a presentation on the Planned Community Act. You have some guests, and I would ask that you please introduce yourselves for the record. And Senator Alvarado, you have the floor, sir.
Thank you, Mr. Chairman, and thank you, members of the committee. I'm Ralph Alvarado, State Senator for the 28th District. Thanks for giving me the opportunity to present what we're calling the Planned Community Act. I think some of you may have known this as an HOA bill or a homeowners association bill that's been presented in the past in various forms. Hopefully all of you have a copy of the proposed draft that we have so far. But this bill has been a slow labor of love, really, that began several years ago as a request from a constituent who was frustrated with his homeowners association in the Masterson Station area of Lexington. He had requested some financial documents and claimed that the HOA was unwilling to provide them. He was concerned that monies were not being handled properly and informed me that he could not afford an attorney to pursue the matter privately. And he asked if I could do something legislatively to require that these documents be provided. So once I began to look into the matter, I discovered that there was nothing in the law to obligate this. So I produced a draft for a bill, as I'm known to do, and this quickly drew the attention of others who have been working on HOA legislation. They asked to expand the issue to cover some of their requests, and in short order, I discovered that many citizens were struggling with homeowners associations and the issues due to lack of legislation, and these things were much broader and much deeper than I had originally realized. To make a long story short, there have been multiple lawsuits, at least in my district alone, regarding homeowners associations and directors who took control of the funds but didn't perform the tasks required for maintenance of common areas. And citizens often would seek help from local county or city officials only to find that they had no jurisdiction over these matters either. Members of the homeowners association have often hired attorneys to try and sue the director or person in charge only to find out that that person was bankrupt or had left the country and there was no law or baseline laws that they could rely on to help run their HOA. So there was often no recourse. I have an example of one very nice golf course in Montgomery County, known as Old Silo Golf Course. Many of you may have known about that golf course in the past. Beautiful development, lots of homes built around it. They got to oversee a lot of greens and fairways. All of a sudden, some of the homeowners realized, hey, the greens are not being kept up. There's weeds all over the place, grass is overgrown, and tried to find out what was going on. They tried to get a hold of the person who was the developer. Couldn't get a hold of them. All of a sudden, all the golf was kind of shut down. The restaurant was shut down. They didn't realize what was going on. Reached out to local officials, had no jurisdiction, couldn't do anything about it. Again, a long story short, 3 years later, lots of attorneys trying to track this individual down. The whole golf course went to waste. And now those folks who were overlooking a lot of these golf course areas are overlooking just plain grass, and they've lost a lot of value in their homes as a result. And unfortunately, this happens in many different ways in our state. I'll go briefly. I'm not going to describe the bill in detail. We can answer some of those questions, but you have kind of hopefully the draft before you. The first section is regarding definitions. The second section regards applicability. The third one is creation and duties of homeowners associations. The fourth section is the declarant control period. The fifth one has to do with easements. The sixth one is management of the homeowners association and board duties. Section 7 is amendments and termination. Section 8 is meeting notice requirements for the homeowners association. Section 9 is quorum requirements for the HOA. Section 10 is financial reporting. 11 has to do with transparency. 12 is with seller's disclosure. The 13th is with common expenses. Section 14 has to do with assessments. 15 with private cause of action. 16 with lien rights. And 17 is display of political signage on properties. I have here a very special guest, someone who's a lot more well-versed on these issues than I am, who could probably answer a lot of questions and give a good presentation on why this kind of legislation is needed for our state. So, Rich, I'll turn it over to you if you want to introduce yourself.
Sure. Thank you. Thank you. My name is Richard Horning, and I am an attorney with a small law firm in Louisville, Hebel and Horning, PSC. And I really appreciate you letting me speak today on this important legislation. Been an attorney for 38 years, primarily small civil practice. We do a lot of real estate work and handle essentially commercial and residential closings, leases, contracts, civil litigation, and a lot of community association representation over the years. We, in our firm, have represented over 600 planned communities in the last 50 years, about half of those being subdivision communities and about half of those being condominium communities. In 2006, I helped, along with several others that are here today from the Kentucky chapter of Community Association Institute, helped form a chapter here in Kentucky because of the need for education and of community association board members, directors, and others that participate in those types of operations. CAI National was formed to provide information and education and resources to HOA volunteers who govern communities and the professionals who support them. Many of those people are here today in support of this legislation, as it is very important to their daily lives. Over the last 35 plus years, we've seen numerous issues in my firm in representation of these communities due to what Senator Alvarado pointed out as to really what mostly comes from poor document drafting. We have, communities where it's a one-page on the plat set of restrictive covenants that barely covers anything, from which then when the folks come to us to help them with the issues that we've shown in some of the slides, they're unable to essentially govern their community because they have no ability to amend those documents, typically without 100% of the community voting to do so. So we've seen drastic issues with that. CAI helped spearhead back in 2011 the Kentucky Condominium Act, which was an update to the old Kentucky horizontal property regime law that affects condos. And unfortunately, that Condominium Act and condominium laws don't affect subdivisions. So there's absolutely zero statutory provisions in Kentucky that help subdivisions. So we modeled this proposed legislation basically from similar legislation we did back in the Kentucky Condo Act to try to give some default legislation in those communities. So the slides that we prepared, and I think you all have been provided, I'm not getting into great detail of. The basic preliminary slide just shows you how many Kentuckians are affected by planned community issues and how important this is to the day-to-day operation of these subdivision communities, where they many times flounder because we have no statutory basis for them to work from. So the problem, as I've already described, and as Senator Alvarado, really comes from poor drafting and inability to provide these board members functional documents from which they can operate. So we have many of our subdivisions that I've represented unable to handle the common area maintenance that when these platted communities are done, they're many times given the responsibility for infrastructure improvements, for taking care of common areas, all the common area fencing, all of those types of things, keeping streetlights on, for example. And then the documents don't provide adequate remedies for passing changes in assessments, for example, from which they can functionally operate financially. We've had issues with transparency issues that Senator Alvarado pointed out, where we don't have full disclosure made. And we've seen in the Condo Act, for example, incredible assistance to new condo buyers as a result of the same disclosure we provide in that act that we're trying to mirror here, from which certain details will be provided to a buyer of any home in Kentucky. So the budgetary issues, the assessment issues, all pointed out in this slide, are pervasive in a lot of our communities that have just poor, antiquated documents that were done 30, 40, 50 years ago without current methods of operation being dealt with and or described in those documents. So some of the examples Senator Alvarado has pointed out, we've had several of our communities that have multiple issues with lack of amendatory procedures, lack of ability to properly assess. One of my communities, we've had to go to court to try to get a declaration of rights to allow them to amend their documents because it's a 460-unit condominium complex that, as their documents currently state and don't state any provision for amendment, would require 100% of all of the 460 unit owners to amend their documents, to allow for changes to assessments, for allow changes to add fining ability, for example. We have most of our communities in the Commonwealth that essentially require court action over any violation and anytime you want to enforce something. So if it's to force someone to bring their trash cans in, you're going to look at spending hundreds, if not thousands of dollars to go to court to force compliance. So having these default basic statutory remedies will give many communities that don't speak to enforcement at all the ability to have those types of enforcement abilities at their disposal. So you see in the slide several other references as far as handling assessments, handling deed restriction violations, dealing with protecting rights to the communities. So the solution, as we have proposed in this legislation, is this Planned Community Act, which has essentially been adopted, as I said, from a uniform model act nationally, so that we can get more efficient governance to our board members. Essentially the determination by owners who have vested interest in these communities, giving them some default legislation where their documents don't speak to it. And that's very, very pervasive in Kentucky, and especially I find that in more of the rural areas where there's really just no documentation for what communities are to be able to do. So, and what's important in the last bullet point on this slide is that we're not altering existing documentation. This legislation will provide default statutes for when the documents are silent. It's not going to be altering existing contractual obligations. So for anyone concerned that this somehow trumps the existing documents community, that is not true. Moving on, and Senator Alvarado already covered most of this as far as the history. We've been trying to get agreed upon legislation for over 5 years now. We've had certain working documents go back and forth. We've made substantial changes, and this draft of the legislation is about a third of the size it was when it began 5 years ago. So we've done, in my opinion, a great job of listening and modifying this legislation to the concerns of other interested groups. So again, the main components of what we're trying to accomplish here are to give those default statutory guidelines from which documents are silent. And so we can provide basic powers to a board, for example, to help with assessment abilities, violation abilities, things like that, setting budgets, getting the financial side of associations, which has been a very, very difficult problem for so many that have to throw their hands up because they can't get the residents to agree to come in masses to properly adopt their amendments they need done, and so they end up essentially kind of either defunct or just continue to do things that they or not do things they should do as far as infrastructure improvements, taking care of the common areas, et cetera. So then obviously the transparent component is so important in my job. I've had many cases go to court over failure to disclose issues in subdivisions until after the fact, after you bought your house and you're living there, and then find out there's been ongoing litigation and all kinds of financial issues in the community that have never been disclosed. So those transparency issues are very, very important. And then just ultimately, the uniform standards that we hope that all communities would be able to adopt as routine from these sections I've alluded to. And this last slide obviously goes without saying, just providing the details from which improved operation and management can occur, increased transparency I've already spoken to, and then just the self-governance methods we provide here for default reasons in case the documents don't speak to those. And then obviously improving the infrastructure and common area maintenance issues. So that really is the basis for this legislation. So thank you again for letting me speak today.
We do have some questions. Thank you both for the presentation. I appreciate that. Senator West.
Thank you, Mr. Chairman. Thank you for the bill. Over here.
Oh, sorry.
So, as a real estate attorney, I'm interested in the bill, and we had a lot of good discussion last year on the bill. And we've got some new rules, where we can't pre-file bills. And just a quick question, and as the sponsor, you don't have to tell me the answer to the question now. I can understand if you would want to wait, but could you tell me, do you intend to file the same version as last year that we ended up with, or have you made changes in the interim?
There have been changes every year. Mr. Chairman is the
I know
chairman
that's
is
a loaded question.
Yeah, no, the chairman is aware. I think when we first started, the very first version of this was kind of an omnibus bill that was hopeful of fixing all the problems and all the issues that we've heard about in the past. And I think the bill was over 40 pages at that time. There was a lot of concerns. We had a lot of feedback from stakeholders who asked for things to be removed and changed, and we did that. I had multiple meetings. The chairman was part of those meetings, and we made as many modifications as we could over the next couple of years. Last year, we took a bit of a different approach, and a lot of the stakeholders said, hey, listen, this is what you fundamentally want to do. Here's what we would recommend. And so they provided language that we presented. There were 3 changes I had made to numbers, and I think that was for those of you who are in the Senate version of this committee, remember that hearing and presented the information there. And there were some things that we had put in before that was not liked, that then was changed, and then there was complaints of that not being appropriate. We wanted to go back to the original language. We made those changes here, trying to be more conscious of just trying to get some basic rules. And so I think this bill is much more pared down. It's different from last year's bill, but it is definitely much more pared down from the original versions that we had. Just trying to be conscious of that, and again, we're trying to provide some basic default rules. I mean, and so often that folks don't have any recourse in when something happens and goes bad. And a lot of our homeowners associations, they're not aware. When somebody buys in, they think, oh, sure, okay, I'll pay a fee every month, and they don't think anything about the rules. But this is it's different from last year's bill, and we're always amenable to changes and feedback. So if anyone here has any feedback or recommendations, we're willing to listen by all means.
Thank you.
Yeah.
Representative McCoy.
Thank you, Mr. Chairman. 2 quick questions, if I may.
Yeah.
First question, is it your intention that this is going to operate sort of like the LLC statute where these are the default rules unless your documents have rules to the contrary that cover the situation?
May I respond, Mr. Chair?
Yes.
Oh, thank you. Yes, that is what we're attempting here. As I said earlier, when you own in a community with those declarations and bylaws existing, those are contract documents that you're bound to. And so we're not trying to obviate those where they speak to these same issues.
Even on a going forward basis?
Correct.
Okay.
It's really mainly for those communities that don't speak to these particular issues.
I might suggest we look at some of that language. It seemed to indicate that if you file one in the future, you must comply with this versus saying...
Oh, yes,
So-
I'm sorry. It would be applicable entirely to new communities filed after this legislation.
So regardless of the size of the community, I've got to have a board of directors with 3 people on it?
Well, yes.
Okay. And second question along those same lines is, it appears to me on the language, on its face, it would apply to something as simple as a common road maintenance agreement. I've got 3 pieces of property that are sharing the maintenance of a road. Is it your intention that the requirements of this law would apply in that situation?
I am not sure I can answer that completely without looking at that particular section, but and this also goes back to your earlier question, this is only when a declarant puts a declaration of record that any of this applies. That's for common communities and multiple lots.
Sure.
So they kind of control their destiny in a lot of those regards. And so those documents, I don't think this legislation mandates a whole lot as far as the infrastructure itself.
I will just note, for those of us that live and do real estate in rural areas, it is not uncommon for a farm to be divided into 5 lots, have a common road, and it would seem to fit that definition. And I would hate for us to have a board of directors and meetings and all this sort of stuff on, are we going to throw some gravel out there every other year? So maybe look at
We can look at
carving that out for rural. Otherwise, I'm afraid the cost of just land development is going to go through the roof trying to comply with this.
Certainly, we can definitely look at that.
Thank you.
Senator Schickel?
Thank you, Mr. Chairman. Last year, Senator, I know we had this legislation. There was a lot of discussion about it, and I found once I got back to my district after the session was over, there was a lot of interest in this legislation and appeared to be quite a bit of support for it. I was wondering, the comment was made we couldn't pre-file, but we can post working drafts, which I think would be helpful in this legislation because it is pretty complicated. And for those of us who are not attorneys, we probably would like to be able to review it before we got in session. It looks to me, from the feedback I've received in my community, that is something I'll be supporting.
I'll remind members, it's on the meeting materials page for the interim judiciary for today's meeting, so you can see that document there.
Thank you, Senator. And really, again, we're welcome to feedback. Like I said, I've been doing this for 4 or 5 years now with this bill, but we've passed it out to all the members, so everybody should have it. And if they want to receive feedback from their communities and things they'd like to see, we're open to that.
Follow up.
Very quickly, and then Representative Kulkarni, you're next.
So is this bill very similar to last year's bill?
This really went back to the initial draft we used 5 years ago.
Thank you.
Thank you, Mr. Chairman. I have 2 quick questions. The first, in one of your slides, you've got a legislative history that says we've removed or significantly altered the most controversial provisions. Just very briefly, if you could touch upon what those were, even if they were broad categories. And then my second question was, you mentioned a model bill. Is this a ULC bill, or are there other states that have adopted similar legislation?
To answer the first question is very difficult because we've modified every single one of these provisions dramatically over the course of the last several years. For example, from comments from other interest groups, we completely modified the declarant control period piece. We've essentially removed a lot of the financial reporting that we had previously and made that much simpler. We've completely modified the seller's disclosure piece, which we're optimistic that actually the Kentucky Real Estate Commission is going to address and maybe make that less necessary from making certain changes to the current seller's property condition report forms. And most of it's just been pared down to make this much more concise and direct. I hope that answers your first question. And then the second one is this is patterned after the Uniform Common Interest Ownership Act, which is a national model act that several states have used and varied the format of.
Thank you.
President Stivers.
Thank you, Mr. Chairman. If I could have just a little bit of latitude with some questions.
I'll allow it.
Thank you, sir. When you start talking about land development and you do, and this is somewhat off of Representative McCoy's questions, when you do a subdivision or land development, you basically put within a document that is placed in the clerk's office with deed restrictions and potentially a plat map and everything else. And so I, as a developer, have Senator Alvarado come to me and say, I want to buy lot 21. Well, he has a contract with me that I have agreed to meet these conditions throughout the development. So when Senator Westerfield comes to me, he knows that he's not going to violate those conditions of at least not having secondary buildings or certain square footage or other things like that within this development. And that becomes somewhat of a contract between everyone. You agree with that?
Yes, I mean, that's what I said preliminarily, that the existing communities that have contract documents, i.e. a declaration, set of bylaws, et cetera, those are binding on all future lot owners.
And I'm just trying to understand, so anything that this bill may have, it could not affect anything that's currently in existence by Constitution, because we would then be interfering with a contract that was already entered into.
That is correct.
So only going forward are those areas that are silent
Correct.
are what this bill impacts.
Yes, sir.
And it might be questionable on the silent part if you can reach back and in some places impact an already existing agreement for land development. That could get a little gray.
Yeah, I mean, I'd have to see what example you're speaking to,
True.
but I think you're correct.
All right, thank you. That's all.
Senator Turner, last question.
As a follow-up, and I think Senator Stivers for his asking that question, is it possible that you put a provision in here that any organization that presently exists or a future organization would want to be exempt from this, because as a landowner, homeowner, and has a unit in a place in Lexington, I wouldn't want to be bound by the terms of this condition of this document I've read. So would it be possible to put a provision in here? Would you object that any organization that's formed, because as I read it now, it's mandatory. It's going to apply whether you want it to or not. If you're going to be forming one of these nonprofit organizations by what you're saying, would you be objectable to some provision being provided that any organization that is organized could exempt itself from this law?
I think that would be completely counterproductive to the goal, because I'm pretty sure probably every developer would opt out if they could. So I don't know that I could endorse that.
All right. Gentlemen, thank you. Senator, thank you very much. I appreciate it.
Thank you, members.
very much.
Thank you, Mr. Chairman.
Good discussion this morning, or this afternoon. All right, we're still morning. All right, we're going to go just a hair out of order to try to accommodate some witnesses. I'm going to bring up the folks from Secure Democracy USA. This is item number 5 on your agendas, the restoration of felon voting rights. Charlie, I don't know who's coming up with you.
I've got a few folks.
I see several listed here.
Yeah, Jason, Greg, Marcus.
Right. I know Mr. Blizzard is on by Zoom.
Another chair, too. Yes. Okay.
Once you get settled, Charlie, if you want to take the lead here, you have the floor. And each of you, as you speak, if you've got remarks you're going to share, please give your name and who you're with on the record here, and then jump right in. Charlie, go ahead.
Wonderful. Thank you, Mr. Chair. Thank you to the members of this committee for the opportunity to provide testimony today in support of the restoration of voting eligibility for Kentuckians with prior felony convictions. For the record, my name is Charlie Olina. I am the Vice President of Advocacy for Secure Democracy USA. We are a nonpartisan nonprofit that works to build confidence in our elections and improve voting systems across the United States. That's work that we've done right here in Kentucky in partnership with Secretary of State Michael Adams. We work across both aisles to educate policymakers and the public about what it takes to strengthen our voting systems. And we collaborate with state leaders, election administrators, policy experts, and other allies to ensure that all citizens have the freedom and ability to vote. We've been working in Kentucky on both sides of the aisle since our founding 4 years ago, and rights restoration has been a focus of ours throughout that time. I'm here to express our strong support for voting rights restoration and to urge you to advance this critical issue. It's estimated that approximately 200,000 Kentuckians are currently disenfranchised due to a felony conviction. Many of these are real citizens all over the Commonwealth who have served their time and are living, working, raising families, and paying taxes in their communities. Yet they cannot participate or vote in our political process. While Governor Andy Beshear issued an executive order to restore the rights of some individuals, it's far from sufficient, and a permanent situation determined by the legislature is needed. We've discussed this issue, our research, which you're going to see a snapshot of, and potential policy solutions with Senate leadership, Senator Storm, and others to work to identify language that both provides a clear and predictable mechanism for folks to regain their voting eligibility that we can all agree on. Senator Storm is on board to sponsor and push legislation. Unfortunately, he suffered a loss in the family and so couldn't be here with us today. But we hope to have language that can be pursued and discussed in the 2023 legislative session. Proposals to restore voting eligibility have been introduced consistently by Republican and Democratic legislators alike. Last session, we supported Senate Bill 223 by Senators Neal and Higdon. That bill proposed restoring voting eligibility to individuals with prior felony convictions immediately upon completion of their sentence, including probation and parole, except for those individuals who had been convicted of treason, bribery in an election, or felony election fraud. This bill restored voting eligibility immediately upon completion of sentence, but included a 3-year waiting period for the restoration of other civil rights. In Kentucky, those other civil rights are defined as the right to run for and hold elected office and to serve on a jury. There are a few principles for fairness in consideration of the policy that I'd like to highlight with you all today. The first is the immediate restoration of voting eligibility for those upon completion of their term of imprisonment, probation, and/or parole. Kentucky's current system leaves restoration to the discretion of a single elected official, Governor Beshear, which can lead to bias and creates an unpredictable environment for individuals seeking clarity on what they are legally allowed to do and what they're not allowed to do when it comes to participating in our elections. The solution that we are proposing would ensure that all Kentuckians will be treated fairly under the law and create a bright line for both individuals who have lost their rights and for Kentucky's elections administrators who need to be able to provide clear guidance around who is and who is not eligible to vote. Today, 43 other states automatically restore voting rights after an individual completes their sentence, including Arkansas, Missouri, Louisiana, South Dakota, and Texas. Second, restoration laws should be applied fairly to anybody who's completed their sentence. Kentucky's restoration laws should not carve out anybody based on the class of crime they committed, except where that crime poses a direct threat to our electoral system. Kentucky's sentencing laws already account for a variety of aggravating and mitigating factors a court could consider, imposing harsher sentences on those convicted of repeat and/or serious offenses. The criminal justice system already punishes people who commit serious crimes with long and sometimes lifetime sentences. We would encourage that Kentucky's restoration laws respect and reflect the established sentencing process of the courts by restoring the voting eligibility of any person who has been deemed fit to return to society and is no longer under the supervision of the Department of Corrections. Kentucky's restoration laws should also cover anyone convicted in another state or jurisdiction who has similarly completed their term. Finally, we would encourage that the Constitution of Kentucky not condition the restoration of voting eligibility upon payment of legal financial obligations, or LFOs. The vast majority of states do not condition restoration of voting eligibility on payment of LFOs. It's a very unusual practice. It's only required in 6 states. And there are some practical challenges to that system. mainly that it creates additional confusion and barriers for voters, elections officials, and correction officials alike to determine eligibility. Given the practical barriers, the Constitution should at most leave this question to the state legislature to resolve in statute. This is an issue that is personal and urgent for every impacted Kentuckian and their communities, as is the need to identify a permanent solution beyond Governor Beshear's temporary relief. There is an active, engaged, and energized network of individuals, organizations, and leaders ready to put in the work to see a referred constitutional measure through to passage at the ballot. What we are presenting to you here today is just a small part of that bigger effort. I look forward to continued conversations with all of you on the issue. Thank you for your time and consideration, and I'm happy to answer any questions after the presentation of the panel. But for right now, I'd like to pass things along to our pollster, Robert Blizzard, to talk about some of the research that we have just engaged in.
Robert, you're on, if you're on.
Okay, I think they just unmuted me. This is Robert Blizzard with Public Opinion Strategies. Thanks to the committee and the folks there for letting us kind of walk through this today. I know nothing is more exciting than listening to a pollster talk through some polling numbers, especially on the phone. And I apologize, I'm kind of in transit today and it's difficult to get there. But I'm going to briefly and briskly, for sake of time, kind of walk through some poll results from a statewide survey among Republican primary voters, and that is registered Republicans with previous, Republican primary vote history. We did a 500 sample, which is a very standard statewide Republican primary sample, and we fielded the survey in mid-September, September 18th through 21. And I believe you all have access to the presentation that I'm going to briefly walk through here. On slide 2 of the presentation, what we found was overwhelming support among Republican primary voters for the General Assembly and the legislature there, putting a constitutional amendment on an upcoming ballot to determine, as Charlie outlined in her presentation, a permanent solution. 70% of Republican primary voters say they would support putting it on the ballot. Just 27% say that they would be opposed. The intensity there, I think, is also important. Almost 40% of Republican primary voters say they strongly support placing this on the ballot versus just 19% who strongly oppose. And so the takeaway I have here is there's no opposition even among the Republican base, if you will, for placing this on the ballot. That is same trend lines when you look at slide 3. When you look at the Republican primary electorate by political ideology, and again, this is a self-described ideology, but among the most conservative Republican primary voters, which is about half of the primary electorate, 48%, they support placing this on the ballot by almost a 2-to-1 margin, 62 to 33, with again similar intensity strength there as well. So a lot of support for placing this on the ballot, and I don't have to do a survey to tell you that both independent voters, even though they are a small sample in the state, as well as Democratic voters, would also largely support placing this on the ballot as well. We then asked some questions about, okay, if it was on the ballot, how would you vote? And the language we used for this survey was on slide 4. This issue would amend the Constitution to allow Kentuckians convicted of a crime other than treason, election fraud, or bribery to regain their eligibility to vote after serving their time, including completing probation and parole. And then ask voters, obviously, hey, if ever on the ballot, how would you vote for it? And on slide 5, by a 53-41 margin, Republican primary voters said they would actually support this amendment. So not only do you have, again, 7 out of 10 Republican primary voters in Kentucky say go ahead and place this on the ballot, but you have a majority of them say that they would they would support this amendment as well if they went to the polls to vote on it. On slide 6, when you look at it again by ideology within the Republican electorate, the more conservative voters in the Republican primary electorate, again, about half the sample, are a little more divided on it, but they are still narrowly in support. Softer conservatives, those who describe themselves as moderate or liberal in terms of political ideology, are strongly supportive of it. And so, again, even an issue where you have very conservative Republican primary voters narrowly in support of it, I think it shows how much support there is for, again, placing this on the ballot, but also when it comes to election time. On slide 7, I ask this very frequently in a lot of surveys, and I think it's important to point out here, this is a do no harm vote for Republicans in the legislature. Placing this on the ballot, and even supporting the amendment once it's on the ballot, is not going to be something that is going to be a big deal in a political campaign. Just 54%, rather 54% of voters say it would make no difference in their vote for a legislator if they supported or opposed placing this on the ballot. And you can see there's, on slide 7, virtually no difference there by political ideology. We also, at the end of the survey, we tested some messaging for the amendment if it were to come and be placed on the ballot. The strongest messages in favor of the amendment, and I know there'll be some more discussion about this after I hop off here, laid out by others on our panel. But the strongest messages are led by a second chance argument that the amendment would be about real Kentuckians who've redeemed themselves, earned back their eligibility to vote. We all make mistakes in life, but under the current law, someone who's convicted of selling ounce of marijuana as a teenager would still be ineligible to vote for the rest of their life, and that Kentuckians basically deserve a second chance. The second strongest message that we tested in support of the amendment is that you still have to earn back your eligibility, and it's making people eligible to vote doesn't mean they automatically get it. You have to have folks earn it back by completing all terms of their sentence ordered by a judge, jail or prison time, probation, parole requirements, any community service. They have to earn it back, which I think is important. And you can see there on the rest of that slide 8 some of the other messages we tested that were strong support for the amendment itself. The other good news for proponents of the amendment on slide 9, after Republican primary voters hear those statements, support climbs. And you can see along the top on slide 9 there, the initial ballot, again, was 53-41. After voters hear that those messages, it increases to 60 to 28. Even very conservative Republican primary voters, who, again, were a little more mixed on the amendment before hearing the messages, become 22 points in support of the amendment, 55-33. And somewhat conservatives and moderate liberal, in the Republican primary are also strongly supportive of it. And then finally, we also asked about a waiting period. A majority of Republican primary voters say they would be more likely to support the amendment if there was an additional waiting period on top of the probation and parole before someone could have their voting rights restored. It's not a significant mover, but it does help drive support for the amendment, even among those who initially are against it, and even among those who are initially for it, as you see on kind of the right side there of slide 10. And then finally, we asked how long should a waiting period be among Republican primary voters? And for the most part, you see here, it's pretty mixed. You have about a third of Republican primary voters say it should be about a year. About 1 out of 5, 21% say 2 years. But then you've got 41%, say 3, 4, 5, or even more than 5 years. And obviously, more conservative Republican primary voters are more likely to say the waiting period should be longer than moderate liberal Republican primary voters who say we should keep it at a year. And so I thought that was kind of an interesting distinction there within the data. So with that is as everyone knows, a very exciting run through of polling numbers via phone, and around lunchtime to a committee. But happy and pleased to walk through that data with you guys. And again, the main takeaways when you look at this polling is there's very, very strong support for putting it on the ballot. A majority of Republican primary voters say they would support it if it was on the ballot. And then, hearing messaging in support of the amendment, does help increase support among Republican primary voters, specifically more conservative Republican primary voters who are a bit mixed on the amendment to begin. So with that, I'll turn it back over to Charlie and to introduce the next person, and I'll hop off.
Thank you, Robert.
Thank you very much for that. I'll hand things over to Jason Hawley, Executive Director with the Catholic Conference of Kentucky.
Thank you, Charlie. Thank you, Mr. Chairman, members of the committee. As Charlie said, my name is Jason Hall. I'm Executive Director of the Catholic Conference of Kentucky. I represent the 4 Catholic bishops: Archbishop Shelton Fobb of Louisville, Bishop John Ifford of Covington, Bishop John Stowe of Lexington, and Bishop William Medley of Owensboro. The bishops of Kentucky and their predecessors have for many years voiced strong support for the automatic restoration of voting rights. I also want to emphasize today the support of the Kentucky Council of Churches, of which the Catholic Conference is a member, along with 10 other Christian denominations and traditions. Participation in the political life of one's community is a right and also an obligation. The tradition of Catholic social thought places great emphasis on the common good, which is defined as the sum total of conditions that allow people to thrive both as individuals and as families and groups. This concept does include a robust concept of rights, but also puts an emphasis on the responsibility each of us owes to help build up the communities in which we live. Voting is one of the ways that we fulfill that responsibility. In 2005, the conference issued a pastoral statement on criminal justice recommending that Kentucky's Constitution be amended so that the right to vote would be automatically restored to former offenders upon completion of all the conditions of punishment imposed upon them by the court. It is our belief that each of us is created in the image of God, and that each person possesses a basic dignity that comes from God. As a result, we have, as I mentioned, certain rights as well as obligations. One is the right and the obligation to participate in the public life of the community. This obligation finds expression in the Catechism of the Catholic Church, where it teaches that exercising the right to vote is actually a moral obligation. We understand the reasons why a felony conviction has historically resulted in the loss of the right to vote. The commission of a crime is a breach of trust with one's neighbors and an act that causes them harm. Society needs an effective justice system to hold people accountable and to protect all of us from harm. However, once the conditions set by that system have been met, the interest of society is best met by the person who committed the criminal act once again accepting and fulfilling the responsibilities to the community. That includes working, paying taxes, meeting their family obligations, and participating in political life of that community. This General Assembly has taken several steps over recent years to encourage and facilitate the process of reintegration into society of those with felony convictions and to reduce recidivism. We have supported and applaud those ongoing efforts and believe that an important step in that process is the restoration of voting rights to those who have completed their sentences. We thank you for your consideration and your support for this effort. Thank you, Mr. Chairman.
And then Greg next. And then Greg Kildow.
Good morning, committee members. My name is Greg Kildow, and I live in Benton, Kentucky. I've been a Kentuckian since the age of 12, when my mom and dad retired from their work as a parole officer and a truck driver, and moved our family from South Bend, Indiana. I spent most of my life in Marshall County, where I went to North Marshall Junior High and Central High School. If you were to look at my resume and my educational and professional accomplishments, you might be surprised to learn that I've been incarcerated 3 times on drug-related charges. It surprised my family, too, because I was one of the kids that never done any drugs. Peer pressure never got to me at all. I was around 35 years old when someone gave me a methamphetamine in a capsule. It gave me an energy boost I was looking for at the time, but ended up costing me more than I could ever imagine. For the next 5 or 6 years, I was never without meth. It sent me down a path where I lost my wife, my sons not wanting anything to do with me. Even my parents wouldn't talk to me. I was arrested in '99 for manufacturing meth, got out on bond after 8 days, received a second charge for the same offense 6 months later. I received a 20-year sentence and served that time in Marion County, Green River, Eddyville, and then finally Paducah. Paducah is where I spent my time at a halfway house. It was there that my life began to turn around. I earned my first degree in industrial mechanics and followed by a second degree in industrial construction. I have nearly enough credits for a business degree now, and this summer I celebrated 6 years of sobriety. Today I'm the general manager of Rad Accessories in Benton, Kentucky, a company founded in 2017 with just 1 employee. I began working there a few weeks after making parole, and today the company employs 11 people. and has grown from 160,000 annual sales to close to 2 million. I am proud to lead this local manufacturing operation that provides good jobs with good wages, ranging from $15 to $30 an hour. Plus, with a business partner, I also own 13 rental units that provide affordable homes for Kentuckians. 10 months from now, I'll complete my parole. Despite the positive steps I've taken to rebuild my life as a productive citizen of our Commonwealth and the success I've found in my career and personal life, I will not be eligible to vote. I'm doing all the right things, including giving back to my community through volunteering, creating jobs, working hard to support myself, my girlfriend, and our 3-year-old child. And yet, I will continue to be punished by being blocked from the voting booth. I've done everything I can to make up for my mistakes in the past, but now my hands are tied. It makes me wonder how I can be trusted to lead 10 people at work daily, but our government still doesn't believe I should deserve to participate fully in our democracy. After everything I've accomplished and worked for, I believe my right to vote should be restored without having to jump through hoops. I'm hopeful the day will come that I can proudly register as a member of the Republican Party and make my voice heard at the polls on decisions that will impact my future, which continues to look very bright. Thank you guys for listening.
Congratulations on your sobriety.
And finally, Marcus Jackson.
Hello, everyone. Chairman and members of the Joint Committee, I am Marcus Jackson, Organizing Coordinator with the ACLU of Kentucky. This year, with community coalition members across the Commonwealth, we launched our Reclaim Your Right to Vote campaign. Our efforts were focused on 3 areas: awareness, education, and the registration of individuals with past convictions. I had the opportunity to engage Kentuckians from all walks of life, and I learned a few things that I would like to share with you today. Like most of the people I engaged, I believe in accountability, and the legitimate government should be operated only by the consent of the governed, and not just those whose lives are without blemish. We believe that people are greater than their lowest moments, and we believe in redemption and a pathway back for lost sons and daughters to reclaim their standing in their communities. On January 21st of this year, I received my final discharge of custody from the Commonwealth of Kentucky, or what I and many others believe, a receipt for our debts paid. On November 8th, the ACLU of Kentucky and all kind of other businesses around the state are going to provide an opportunity for individuals to go vote. The ACLU will give me that opportunity and time off to go vote, but I cannot vote because of a 1992 conviction. The irony of the whole disenfranchisement is that the very behavior society encourages, the commitment to the larger social and political collective, is undermined by a law that denies the right to vote to people who desire to engage in that way. And I am one of those individuals. Thank you for listening.
Thank you both.
That's the whole dog and pony show, so we can answer any questions if you have them.
We do have a couple. Thank you all. Senator Wheeler.
Thank you, Mr. Chairman, and I have a couple, if you permit. I guess my first question is, I'm all about second chances. I don't have an issue with that concept. I guess my concern is, what if you had a situation with a repeat felony offender in the sense that you had multiple crimes? I mean, would they be restored after the serving of the sentence on each one?
So, yes, unless the second offense was committed while they were still, on probation or parole under the supervision of the Department of Corrections. But again, courts will take repeat offenses into consideration of their sentencing, and there's actually a lot of research and studies to show that rights restoration is part of a successful reintegration program and also can help reduce recidivism. So Florida's Parole Commission found that those individuals who had been released and had their rights to vote restored were 3 times less likely to reoffend. when folks are feel like they are a valued part of their community and their needs and concerns are being addressed, they're less likely to engage in future crimes. I don't mean to say this is a panacea for all crime, but it is an important part of the puzzle for improving public safety.
Okay. And I guess my second question is, as I understood your presentation, the goal would be even if somebody in an alternative jurisdiction completed the requirements of that jurisdiction, that Kentucky would automatically recognize that and restore the rights of that person. You know, I think we've seen countless stories, especially over the last couple of years with the increase in crime. That's, I think, a real problem in the United States of America, that you have places such as, I think, George Gascon, the prosecutor in Los Angeles, where they actually have tapes of criminals in jail basically talking about, well, this guy's, great. We can get right back out on the street. He has minimal to no punishment on these types of things. And some of these people are really bad people, and it has just led to an explosion of crime in certain jurisdictions. And although I can imagine that most of these people would not want to move to Kentucky, but if, I don't think they'd probably quite find the same welcome here. If they did, I guess I have a concern, at least maybe in some urban, with the efforts to elect certain prosecutors that are soft on crime, that you would have a, a less even-handed application of justice, which could result in particular disparities where you would have persistent criminals in urban jurisdictions having their rights restored, but perhaps in more conservative jurisdictions you would not see that occurring as often. Is that a scenario that you could potentially see happening?
Well, thank you, Senator Wheeler, for that question. I understand your concern, but there's no evidence that voting rights is directly tied to somebody's willingness or unwillingness to commit a crime. Before you commit a crime, you're probably not thinking, oh, but I won't be able to vote now. And so it's not particularly an incentive necessarily in the ways that, is going to result in the kind of soft on crime environment that you're describing here. And in many ways could actually help to prevent additional crime because of that effect on.
But I think that we have seen that in some of these jurisdictions, like on the West Coast, where people are very aware of the circumstances of the type of elected officials they have is directly proportionate to how much time they're going to be incarcerated. So I think this could end up being a very vicious cycle in areas that are already high crime areas, where you would have folks that would be focused on electing people that are going to have a soft on crime approach. But and I'm not saying that would occur in every circumstance, and I think that people that show a true effort to redeem themselves over a period of years, that there should be a second chance for those people if they've gone 10 or 15 years without committing another crime, or even 6 or 7 years. But I think that the idea that that these people should be automatically restored and given back all their privileges is something that causes concern for me. Thank you, Mr. Chairman.
If I may respond, Mr. Chair, I think, again, Senator, I understand your concern, but I think at the same time, a few things to clarify. One, folks living in suburban and rural communities are far more likely to see the inside of a jail cell than those living in urban areas. That's true nationally. That's true in Kentucky as well. Rural communities are increasingly making up sizable populations of the incarcerated population. Furthermore, we feel that parole and probation are those waiting periods. You've heard today, Marcus, how long has it taken you to come off probation or parole? 4 years. that is what is designed by the courts to be the period of reintegration, the period of proving that you can be a productive member of society. It's folks that are still under the supervision of the Department of Corrections, needing to meet goals, establish benchmarks, and be reintegrated. So we think that if somebody is safe enough, considered, fully off papers and deemed fit to return to society, then why continue to punish them if the courts have decided that they've paid their dues and repaid their debt to society? That's our position on that.
Representative Blanton, excuse me.
Thank you, Mr. Chairman. First of all, Mr. Jackson, Mr. Kidlow, congratulations to both of you all. I wish that 100% of people who have made some bad decisions in life could follow the path that you guys have. And I do think we need to look at something to help you to further that path and that success. But I do have a couple clarifying questions. Ms. Molina, if I understood early on in your testimony, you mentioned something about 3 years later about some rights, and you mentioned the right to hold office, the right to sit on a jury. Am I correct in that?
Yes, sir. Yes.
Okay. But there's a third one, and you list 3 crimes that wouldn't be impacted by this: treason, election fraud, and bribery. But that third one, correct me if I'm wrong, is the possession of a firearm.
That is another civil right, but it's addressed somewhere else in statute. And so it does, for the piece of the statute that we would be addressing, or piece of the Constitution that we would be addressing with this bill, it would not touch firearm ownership. That's handled separately. So for the purposes of this and the part where we're proposing to change, it's just those running for and holding office and serving on a jury that are included in that particular section as other civil rights.
Okay, because I would definitely have a problem with 3 years later allowing possession of a firearm by somebody who committed murder, right? That would be an issue. Also with a sex offender, then do we take them off the sex offender registry? If we begin to restore those rights after 3 years, I'm just questioning, because I want to make sure if we're going to do something, we do it correctly, that we provide to the people who've earned it, these rights, but also make sure we're providing protection for the citizens at the same time from those that maybe are still a threat to some degree, okay? Next question, and this is more of just a personal question for Mr. Hall. You mentioned that voting is a moral obligation, and I guess my question would be, because we only see, if we're lucky, maybe this year, since we're having local elections, we might see some counties get close to 50%. If it's a moral obligation, then those that's not going and voting, are they sinning?
Well, I can give an extended treatise on the theology of sin if you would like, but what the Catechism teaches is that love of neighbor includes participation in one's community and being solicitous of the good of the community, and in a democracy, voting is a key part of doing that. Now, whether it's a sin or not depends on your intention and the state of what your intent is. If you're saying, I hate my community and I don't want to participate, then probably is a sin.
Thank you, Mr. Chairman.
Who had that on their bingo card this afternoon? Senator West.
Thank you, Mr. Chairman. My question is, I think we're going to agree, but just want to clarify that what you're saying is what I think you're saying. So we've talked a lot about the constitutional amendment, okay? Is it your all's opinion that in order for the legislature, in order for us to do something in this area, make the changes that you want, that we have to do it through a constitutional amendment, that we don't have the latitude to do it through revised statute. Is that your opinion?
Correct. Yes, Mr. Senator. Thank you.
Second question is, so the governor has given us an executive order in this area. Would that executive order therefore be unconstitutional because it seems to be in total conflict with Section 145 of the Constitution? Is that?
My understanding is that the governor does have the right to issue those executive orders, as he has power of clemency, for example. But we also don't think that it should be his decision. We think that it should be this body. We think it should be. This kind of decision belongs in the hands of the legislature. We are asking you to, refer a constitutional amendment. We understand what that takes and the obligation that comes with that request. But we think this is the issue for y'all to address, and I think an opportunity to kind of take back the issue in some ways as well.
I agree with what you're saying. I agree with that. If we are going to do something legislatively, I think our only route is through constitutional amendment, because it's Section 145 is pretty tight. But I just want to clarify that. Thank you.
Yep, that is our understanding. Thank you.
Senator Turner.
Thank you, Mr. Chairman, and thanks for all of you all being here. Being married to a Catholic lady, I get that little verb every now and then. I've been practicing law 44 years, and I've done a lot of criminal law. The question I have is, normally we speak to the jurors. I practiced criminal law for 44 years, and the jury will sentence somebody, but then the administrative and through the court system, it takes over. And it's the one that decides really what the time is. I mean, the gentleman here says he's got 2 more years of parole. And I guess the first question I have is he asking that in his case, would he want his time to be stopped already and have the right to vote now, or is he willing to wait till his parole time is up, which may be a lot shorter than actually the jury sentenced him? I mean, or unless he made a guilty plea. So that's the question I have. What is the position you all take on? That's the first question.
Yeah, I think thank you for the question, Senator. For Kentucky, I mean, what we have currently is a lifetime ban, no matter what, no matter how long you have been off papers. You can't vote unless a single elected official and the governor says that you can. We don't think that's right, and we don't think that that's fair. What we are proposing here in the bill that we supported last session required full completion of the sentence. For this issue, I completely understand and hear your concerns around sentencing, but we think that should be addressed through statute and separately than the constitutional change that we're asking to make here. That's kind of our positioning here.
Mr. Chairman, further ahead.
Yes, sir.
To clarify that, though, I said first that the jury does the sentencing. I'm sure his parole will end if he had a jury trial, probably sometime before his sentence would have been if he would serve the full time, because we give him credit and all that. So my question still is, for the purpose of the public knowing that a jury is who we rely on, unless you do a plea, is the time that you're asking that when we do legislation, constitutional amendment, or whatever, right to vote end, because it's going to be different unless we set some specific time frame. Is it going to be the jury sentencing time? Because it can always be cut short by the probation, parole board, the court sentence whenever the judge reduces it from a jury. We're not going to have something and I'm trying to find out legislatively, looking forward, what are you all asking that rule be? Is it what the jury said, that the time that they're going to be then given the right to vote again? And I'm familiar with the Kentucky statute. You can carry a gun in Kentucky if you didn't get convicted before 76, and you can hunt. Now you can't. Federal law is what keeps everybody from carrying a gun now. Mm-hmm. Kentucky statute's what controls it, but that's not an issue. I want to know, so when we as legislators start working on this, what your position is as when you want that voting right to take effect, because it's going to be different in everybody unless we say it's going to be the jury sentence or your plea sentence because it can always be terminated, shortened, and by certain acts, by just the way the administrative process works, because they can get a little bit of trouble and they get their time extended. I know the process, but you are going to have to ask us to put it something very specific, and that's what I'm trying to get you to tell us.
Yes, apologies, Senator. I misunderstood your question the first time around. What my understanding of the language that we are proposing is that the completion of sentence, terms of probation, and parole would be as it's defined by the Department of Corrections. And once an individual is no longer under the supervision of the Department of Corrections, including the Division of Parole, that would be the kind of clear, bright line when you're off papers to say, okay, now you can vote.
And then in the gentleman's case, it's when his probation stops 2 years from now, as I understand, parole, that's when he would ask to have the right to then start voting again.
Correct.
Clarifying. Thank you very much, ma'am.
Thank you. Apologies for that.
Senator Schroeder.
Thank you, Mr. Chair. I want to discuss the current situation that we have. I'm right here.
Thank you.
And gentlemen, thank you for your testimony today. And much like Representative Blanton, congratulations. Thanks for sharing your story. And it's a great example. We don't hear enough about success cases, so thanks for being the success. Regarding the current process, have you guys applied to the governor's office? And I'm curious, do you get a reasoning back why it's denied? And then I'd like to hear if anyone's keeping statistics for the percentage that are denied, and educate me with that process. If the governor's office is it a blanket no, yes, how that works? But first, I'm just curious how that process has gone for you guys.
Go ahead and take it, Marcus.
Yes, I applied. I petitioned the governor for the restoration of my rights. No word, no nothing. Followed up calls, no word, no nothing. A lot of people that we've been working with, we personally assisted someone 2 years ago with the petition of their rights for a possession of a drug offense, and still no word, no nothing. It's just sitting in limbo.
Let me add, do you get a confirmation that you've applied even? Is there some acknowledgement that you've asked?
Not initially. If you call and you tell them that you have applied and everything, then we get the same prompt. It's being considered. It's on the desk. We'll let you know if you get it, but there's no requirements to let us know if we are denied.
Wow, okay.
Thank you. That's helpful.
And that's a big part of why we think that's a problem, and we need the permanent solution led by the legislature.
Anything else, Senator?
Well, I'm curious, do we have numbers? Do we have a percentage of even people are applying? But I guess that you wouldn't necessarily know how many people are applying. There's no way to, unless you did an open records with the governor's office, I guess. Has anyone done that? Or
I don't have access to that information, just off the top of my head. But yeah, I believe that within the kind of network of folks working on this, they have requested those records in order to be able to notify folks that their rights have been restored or they've got an opportunity to be able to petition or
I think
vote.
it's a good question, Senator. I'd ask staff if they wouldn't mind transmitting that question to the governor's office and asking.
I was just going to suggest that, Mr. Chair. I think that would be really helpful as we go forward, but just even hearing that there's not a response at all is helpful in our decision making, so thank you.
I agree. Thank you. Good Senator. Good question, Senator. Representative Nemes.
Thank you, Mr. Chairman. It's obviously clear where I am on this bill. I've carried it before. I want to note I represent a community that we do have a very high crime rate and going up, mostly caused by young folks. And so at some point, hopefully they stop committing crimes and so forth. So I've started looking at these criminal justice issues a little differently recently. And it's about the holistic, it's about the person, obviously, making them holistic, making them a good father, getting them back in the community, going back to work, being a taxpayer. But I want to look at it a little bit differently, and I think, Charlie, you said you talked on this a little bit, and that is what it does for recidivism rates. So I'm going to start asking this question on every criminal justice bill. What does this do for victims, for future victims? Mm-hmm. So I want to make the person who committed crime, I care about that person. They're a human being. They have dignity. But I think we should focus more on future victims. So help me understand how this, And I want to note, by the way, that our crime rate is not related in any way to people getting their vote restored or not. In my view, it's a lot of other things. But so someone articulate the message to me and to the people who are watching, the Kentuckians. How does this help reduce future potential victims?
Thank you, Representative Nemes, for that question, and also thank you for championing this issue in the past. Victims are at the moral center of the criminal justice system. But at the same time, the kind of survivors and victims advocacy groups that I've spoken with about this issue, believe that, yes, perpetrators should be punished in accordance with the law in their sentences, because that is the way to do justice to the victims and the community. But victims have also, across the country, and advocacy groups that represent them have joined this effort and pushed for reform here, because it's a part of the rehabilitative process. It's a part of the healing process for those who have harmed and for those who have been harmed. There is a study, for example, from the Alliance for Safety and Justice that found that 6 in 10 folks who had been the victim of a crime would prefer a system that is more focused on prevention and rehabilitation programs, and that will fully offer the opportunity for individuals to reintegrate into their communities and be productive and supportive members of that community. And so I hear that, and I think that is extremely important in this issue. But also, in my experience, this has been an important part of the healing process as well, and the rehabilitation process of individuals who have caused harm.
Mr. Chairman, quick follow-up.
Yes.
I think it's important to note that what current victims think, but here's what I'm getting at a little bit more than that. I think it's a fine answer. I think we should support this for a lot of reasons, but let me tease this out a little bit here. Because it will limit future victims, not people who've already been victimized, right? When we say recidivism goes down, that's a scientific way of saying somebody's not going to be a victim in the future that might have otherwise been. These folks are going to re-enter our communities. They're going to be our neighbors, right? So we need to do what we need to do to try to get them back into the fold so they don't hurt somebody else. So you guys need to, I think, refocus, because I think this is what we're trying to hear. We want to rehabilitate. We want to hug everybody. And okay, great. Well, fine. But that's not what we're trying to do.
Right.
We're trying to reduce crime. And we use all those beautiful words, big words, recidivism, rehabilitate. What matters is your neighbor down the street, fewer of them will be victims in the future. So we need to be better at articulating that message, because we're not going to pass this if we're saying we're making the criminal a better person. No, we are reducing future victims. That's what the message has to start to be in all these criminal justice bills. We need to start with the victim, the middle needs to be the victim or potential victim, and the end needs to be the victim. If it's going to reduce future crime, then say it clearly, and back it up. Thank you, Mr. Chairman.
Representative Decker.
Thank you, Mr. Chairman, and thank you for such a thorough presentation and for the personal testimonies. They're compelling as well. About 6 years ago, I was in a group that was talking with local criminal justice officials, judges, prosecutors, sheriffs, police chiefs. One of the things they said was shocking to me. I have been a lawyer for a long time, worked in civil litigation, not criminal. I remember hearing, seemed shocking, but am clear I heard that it takes 7 offenses to get a felony because of shock probation, different things that happen. Deferrals, pleading to lesser crimes. And so I'm concerned about that before a felony conviction. Secondly, I'm worried about high recidivism and wondered if you have when you talk about second chances, I believe in those completely, but maybe not 7 chances. Also, about recidivism, do you have any statistics about whether that occurs during this probationary parole time or afterwards, so that someone has served? Do you have that kind of statistics?
Yes, Representative. Those studies were based off of folks who had come off papers, so they had finished probation and parole.
What about the 7 chances? What do you think the is behind there, that statistic?
Representative Decker, I'm going to be honest, I am not a lawyer, and I'm not sure that I can speak with 100% accuracy to that exact question. So I would love to follow up with you when I have a chance to call the lawyer and he can tell me the right answer here. But I don't want to misspeak.
Thank you.
I appreciate it.
Last question, Representative Elliott.
Thank you, Mr. Chairman. I'm down front here. Appreciate your remarks and good afternoon to everyone. I noticed that 43 states automatically restore voting rights, so that puts Kentucky in a very extreme minority of states that don't automatically do this. In the bill that we saw last year, 223, there were exceptions for treason, bribery in an election, and election fraud in those 43 states that automatically restore. Are those consistent exceptions throughout those states? Is there anything else that those states have that wasn't in that bill, or is that pretty uniform across those states?
Thank you, Representative, for that question. So I will say bribery in an election, election fraud, and treason are kind of the standards that if a state does carve out specific crimes, they are carving out those. There are a handful of states that do impose additional carve-outs, but they're extremely specific. And so, for example, first-degree murder or, a specific crime. In Governor Beshear's executive order, he went very broad in terms of violent felonies. I want to be extremely clear that no other state in the nation has those kinds of broad carve-outs. If there are carve-outs of specific crimes, it's very specifically enumerated in order to provide that clarity. And I think that's one of the other challenges with the governor's executive order is it's been difficult for individuals to determine whether, what crimes count and what don't.
So it wouldn't be out of the norm if we were to add 2 or 3 really heinous crimes to the 3 that we've outlined. That wouldn't be out of the norm nationwide to do that. But you're saying a broad swath of saying violent felonies.
Yeah.
That is abnormal or not consistent across the country.
Yes. So 31 of those 43 states don't include any additional carve-outs beyond that treason, bribery, and election. So it's still a vast majority of the states don't address those carve-outs. If they are addressed, that would be my response is to get very, very specific. But our positioning still is that, sentencing happens elsewhere. And for particularly egregious crimes, there will be, particularly strong sentences. And so, regardless of the individual or crime or circumstance that we're talking about, here we're talking about folks who have done everything that the court said they needed to do to repay their debt to society. And so we don't want to get too deep into, carve out this crime, carve out that crime, carve out this crime, particularly because support starts to drop for the amendment when you start to do that. This is something that has been very interesting to learn by polling Kentuckians. But for example, in our poll last year, we started with 79% support. When you said, accept all of these crimes, the more you add, the lower that support goes. So also from, a viability standpoint and success at the ballot, I'd encourage those carve-outs to stay narrow.
Thank you, Mr. Chairman.
Yes, sir. You mentioned, Charlie, Arkansas, Louisiana, Missouri, and Texas. Do any of those states have those carve-outs or any carve-outs off the top of your head? And I know I'm putting you on the spot, but you mentioned those, so I'm curious, as exemplars, whether or not they have that.
Yes. I would have to double check because I'm not finding
fine.
it closely in my notes, Senator.
No
I
worries.
apologize, but I can get you that answer for sure.
I was getting you cold on that specific detail. No worries about that. Senator Carroll, I'll let you close us up on this panel.
Thank you, Mr. Chairman. Just quickly, so no other states have addressed the repeat offenders? There aren't exceptions for that?
So some states do. I can try to find the answers around that. I believe it's my understanding that Arizona treats second offenders differently than first time offenders. So I would be happy to prepare and share that information with you, but I'm not sure I can answer that off the top of my head.
Okay, thank you, Mr. Chairman.
Thank you, Senator.
Thank you all very much. I appreciate the discussion. I know the committee does too. Charlie, thank you. It's good to see you again. Appreciate your
Good to see
helpful
you.
information and testimony.
Thank you very much.
While they're clearing out, I'm going to have no stranger to the committee, Josh Crawford with the Pegasus Institute coming on up here. I want to mention, again, highlight the materials that are online. The bill, Senator Alvarado's bill draft proposal is there, which I encourage you to review. Those of you that had questions, those of you that were thinking about questions but didn't get your name on the list. Also, I know the League of Women Voters submitted a letter in support of the panel we just heard and that proposal, and that's in the materials as well and online. So please be sure and check all that information out. I know the Catholic Conference statement is there, Secure Democracy statement's there, and their slide deck with the polling information if you're curious. And our last discussion of the day is on solitary confinement. I don't want to spoil the ending here, but when I had a meeting with Josh, who many of you know and have met with one-on-one on any number of occasions, we had a conversation many months back, and he shared some information about Kentucky's own use of solitary confinement, which I found stunning. And I put it on my little list of interim topics for us to dig into, and I asked him to come and share that with us today. So, Mr. Crawford, you have the floor.
Well, thank you, Chairman Westerfield, for the opportunity. I owe you, Chairman Massey, and Representative Bratcher an apology. This is the second time you have had to look at my face today, and I recognize it's not a great face, so we will get through this together once again. As was mentioned, the presentation is on solitary confinement, both a sort of national perspective and its use here in the Commonwealth. First and foremost, what is solitary confinement? For the purposes of this conversation, we are primarily talking about administrative and disciplinary segregation, not segregation for the safety of an inmate, protective custody, that kind of thing. We're talking about administrative decisions and then disciplinary segregation. Solitary confinement is the practice of isolating inmates for 22 to 24 hours a day with little human contact for periods ranging from days to years. It limits access to educational or rehabilitative programming. Solitary confinement as disciplinary segregation is a punitive response to inmate behavior, and in the short term can be a useful administrative tool to help ensure inmate and staff safety. Long-term solitary confinement has repeatedly been found to have deleterious effects on inmates and increase recidivism. Representative Nemes, it looks like, has exited, but there will be a substantial portion of this presentation about recidivism. The concept of an academic consensus is relatively rare in truth. On most issues, you can find reasonably high-quality research in peer-reviewed journals that come down on both or multiple sides of various issues. When it comes to the impact that long-term solitary confinement has on both inmate mental health and recidivism, though, we get about as close to an academic consensus as there is. So, sort of a national picture. On any given day in 2019, the last year that we have full available data, there was an estimated between 55,000 and 62,500 inmates had spent the previous 15 days in solitary confinement in just state and federal prisons, so we're not talking about local jails here. The use of punitive solitary confinement has grown faster than prison growth. So over a time period in which prison populations grew by 28%, the number of prisoners in solitary confinement grew by 40%, and a 2003 report estimated that nearly half of all prison inmates in solitary confinement had some severe mental illness. We'll come back to that in a little bit. So the impact on inmates. Virtually every study on the impact of solitary confinement, again, we're talking specifically about long-term solitary confinement here, finds adverse impacts on inmate mental health and behavior. This is subsequent behavior to release from the institution or release from solitary confinement. So studies find that both inmates behave more poorly upon release from long-term solitary confinement and that they recidivate at higher numbers. We'll talk a little bit about that in a minute. These mental health impacts include everything from hypertension, uncontrollable anger, hallucinations, emotional breakdowns, chronic depression, suicidal thoughts, and behaviors, as well as anxiety. This is particularly true among inmates who already have serious mental health challenges, serious mental illnesses, which again is about half of the prison population as it relates to solitary confinement. Juveniles and pregnant women. This committee may remember that a number of years ago, Senator Adams sponsored a Senate bill that actually exempted pregnant female inmates in the Commonwealth from solitary confinement. So on that particular question, the Commonwealth is very much ahead of the curve. The impact on recidivism. So studies have repeatedly found that placement in solitary confinement has a negative impact on recidivism. Additionally, the longer the stay, the greater the negative impact. And so if you're talking about 30 days versus 6 months versus 6 years, that impact plateaus at a certain point, but it grows over a certain point as well. One study found that long-term solitary confinement increased the risk of being convicted of another crime within 3 years after release by about 15%. Another evaluation in Texas found that inmates released directly from solitary confinement had a 12% increase in recidivism. An evaluation of prisoners in Connecticut found that 91% of prisoners who were released from solitary confinement committed a new offense within 3 years. That was nearly double the control population for individuals who had not been in solitary confinement for a period of time. So in Kentucky, as I already mentioned, Senate Bill 84 not only banned the practice for pregnant women, but required some data reporting. Representative Heverin, ahead of the 2022 session, requested some additional data in support of House Bill 615. And I want to share some of that data with the committee here. Here we have the number of individuals who were placed in a restrictive housing unit. This indicates how many times these individuals were placed in a restrictive housing unit. So this is not days, this is number of times that an individual was put in restrictive housing. Obviously, 1 or 2 stays is by far the most dominant, and it sort of goes down from there. 4, 5, and 6 have about the same numbers. You see those numbers decrease some in 2020 and 2021. This is largely, in my opinion, a result of responses to changes in correctional policies related to COVID-19. This is all information that I believe you all should have available to you, and I can share the larger data and graphs as well. Finally, this chart indicates the number of days spent in a restrictive housing unit. Again, 6 days or less, 7 to 29 days, those are your largest chunks. That's not really what we're talking about here. But in 2021, there were 1,400 inmates who spent between 30 and 90 days in a restrictive housing unit. We had 44 who spent the entire year, somewhere between half the year and the entire year. I am not entirely sure what the over 365 designation is. This came directly from the Department of Corrections. They would have to answer that question. I don't know if that's people who carried over from previous years, but I'm not entirely sure what that over 365 designation accounts for. But so you're talking about, close to 2,000 inmates last year who spent 30 days or more in solitary confinement. And given the detrimental impacts both to inmate mental health and subsequent recidivism, you're talking about a reasonably large portion of people who are going to have those negative impacts. Importantly, there are alternatives to solitary confinement. So the North Carolina Department of Corrections has what it refers to its therapeutic diversion unit. This is a specific unit that focuses on inmates with severe mental illness who've repeatedly found themselves in solitary confinement, offers a tremendous amount of service that works directly with those individuals, puts those individuals in a community where they don't have to find themselves in these restrictive housing units. An evaluation of that program in North Carolina found both lower rates of recidivism for those inmates upon release, found better conditions for staff and other inmates, and fewer disciplinary responses to those inmates within that therapeutic diversion unit. This, again, all takes place within the confines of the facility. There are also a number of programs that allow for segregation with longer periods of time outside of the cell for programming and recreation. The Colorado Department of Corrections has sort of set up the model for this, where they have sort of a step-down process. If you find yourself in solitary confinement but you are low risk, then you spend more time in programming and recreation and a little bit less time in the cell. If you're high risk, I think the maximum amount of time that you have is something like 3 hours for programming, 1 hour for recreation. So you're still spending 20 hours a day in the cell, but that is for sort of your highest risk cases. There have been a number of jurisdictions that have established review processes for once an inmate is placed in solitary confinement after a period of time to basically plan and say, like, okay, rather than leaving this person in solitary confinement for a prolonged period of time, what is the process by which this person can either make their way back into the general population, make their way into a specialized unit, what North Carolina does, or ways that we can get this person more resources or more involved in the prison community. Finally, there are a number of states that are leading the way. I have a number of friends at think tanks in Mississippi, and this is something that people don't get to say enough, and so they're going to be happy that I am. But Mississippi is really leading the nation on this in a positive way. They have substantially reformed the way that they deal with segregated populations in solitary confinement. They reduced the solitary population within one institution from about 1,000 inmates to 150, and then eventually closed that entire unit. They estimate savings because of the lack of staff needed for some of those high-risk units of about $8 million annually of being able to divert away from that. At the same time, they reduced violence levels among that population by 70%. Maine did some similar things, was able to reduce its population by 50%. Texas and New Mexico have commissioned studies to evaluate how solitary confinement is used in their states. And then finally, Alaska, Connecticut, Maine, Nevada, New Jersey, New York, Oklahoma, West Virginia, and Texas, which is about an eclectic group of people, a group of states as you can get. None of those folks will be voting together next Tuesday. All passed laws either severely limiting or prohibiting the use of solitary confinement for juveniles. Juveniles are, again, one of these populations that the negative mental health impacts are more substantial than they are for the general population, and so they have either severely limited the practice or outlawed it for juveniles altogether. So before I take any questions, I think it's important to note that placing an inmate in solitary confinement is the greatest deprivation of liberty that the state can impose upon an individual. That doesn't make it inherently wrong, but it does mean that it ought to be scrutinized with the seriousness that it deserves. It is a useful tool that exists on a spectrum. For short stays, it can be a valuable tool. It can be an important tool. And unfortunately, it's oftentimes the only tool that our corrections officers are given. But expanding those tools and making sure that it doesn't end up on the wrong end of the spectrum in which those effects are negative, both for long-term public safety and those inmates' mental health, is crucial to making sure that we not only treat inmates humanely, but that we reduce crime in our communities. So with that, I'll take any questions.
Thank you, sir. Representative Banta.
Thank you for your presentation. So kind of two parts. Are you proposing a North Carolina model? Or what? I would never want to take away the solitary, only because I think that sometimes is the only tool in the toolkit, especially since our prisons have become mental health wards in many cases.
Yeah.
So
there are a couple of suggestions I would make as it relates to that. The first thing to do is to equip corrections officials with more tools, right? Before you ever have a conversation about taking tools away, is to equip those individuals with more tools. And then the second is to take a serious look at what long-term solitary confinement looks like and rolling back that as a process. Again, I don't think that you need to reduce the use of solitary confinement, as you saw in the data for most of those cases where you're talking about several days at a time. And there are a number of states, Mississippi, Maine among them, who basically put parameters up that said shall not exceed X number of days in Y number of month period. That kind of thing can be helpful on that front. But I think it's important in this conversation to address all of those things, to equip correction staff with more tools, to create processes by which individuals who are placed in solitary confinement have successful pathways out, and that we certainly never release anybody back into the community directly from solitary confinement, and that we look at limiting its long-term use, not its use generally, not its use as an administrative or disciplinary tool in the short term, but the evidence is pretty clear about the negative impacts over the long term.
Okay, thank you.
Representative McCoy.
Thank you, Mr. Chairman. More of a comment than a question. Through no fault of my own, my career has become one of suing jails for people that die in incarceration. And I can tell you the use of solitary confinement in Kentucky is absolutely horrendous. Even when we have procedures in place where why a person is in there and how long they're going to be will be reviewed, it doesn't happen. And the standard in our state is that every officer in a jail can unilaterally put someone in solitary confinement for up to 5 days. And once that's done, there will be no review and no one else gets to let them out other than that officer. And they do that so that the officers feel like they have the power. I won't get into the war stories, but people have been left because, quote, I forgot I put her in solitary confinement, and they've died there. And it happens all over this state. So as this committee goes forward, I won't be here next year. Hope you look at this, but don't fall prey to but we've got a review process in place, because if nobody's checking to see that it's happening, it's probably not going to be happening. Thank you.
Thank you. Senator Schickel.
Thank you. Thank you, Mr. Chairman. We've talked about this. I've talked about this quite a bit with the presenter already, and I'd like to ask for some leeway if I could, Mr. Chairman.
Yes, sir.
Thank you. I've talked a lot about, and a couple of things. This is a real, I would say almost an emotional issue for me. Being a former prison administrator, jail administrator, having worked in a jail, I listened to Representative McCoy, and he makes his living suing jails. Well, I make a part-time living defending jails in federal civil rights cases as an expert witness, and there's definitely two sides to this story, and I guess it's a little bit follow up on what Representative Banta was talking about. You present an academic argument, and a good one. Much of it I agree with. There's no question at all that long-term solitary confinement causes mental illness. Although I would tell you most people that are put in solitary confinement are unfortunately already crazy. But there's no question about that. But when you're in a cell block at 3 a.m. and you've worked 24 hours and you're all by yourself, limiting options, and you're not talking about someone that has a lot of education. I'm talking about the employee now. You're not talking about somebody that has a lot of education, knows the law. All they know is, I disagree with Representative McCoy. Most correctional officers are just trying to do the best job they can. And I don't think any of us have ever been faced with these kind of choices. I can't think of a group of people more beat down other than police officers than correctional officers. And they're just trying to do the best they can. And as you say, solitary confinement is about the only thing left that they can do 99% of the time to maintain the larger order in that facility and to protect the person that's in solitary confinement. You make an academic argument, the difference between punitive and safety and discipline, but that's a very academic argument. When you're in the fight, those kind of lines aren't as clear. And the Kentucky Jail Standards does have policies about these things, and we do have a Kentucky Jail Standards Committee, and all our state institutions are American Correctional Association certified, and they all have policies and procedures for solitary confinement. So as we move forward, let's not get too excited about all these horrible things that are going on, and let's think about the larger picture of the people that we place in these situations and what they are going to have to live with, because I don't see anybody sticking up for them. Thank you, Mr. Chairman.
Thank you, Senator. Any other questions? Seeing none, thank you, Mr. Crawford. I appreciate your presentation. Thanks for your patience as we switched up the agenda. Members, we have one more meeting. This is not our last meeting. We have a meeting in December on December 15th. Right back here in this building. So I look forward to seeing you there, and I wish you all a happy Thanksgiving.